This video is going to deal with changes to European succession law, which is essentially the law which determines who receives your movable and immovable property when you die. Immovable property is of course buildings and land, while movable property is everything else. Specifically, the video is going to deal with EU Regulation 650/2012, which marks the biggest change to European succession law since the Romans. Regulation 650/2012, which is also known as Brussels 4, is effective from the 17th of August 2015. We'll just call it the regulation. Although the UK has opted out of the regulation, it'll still affect all Britons with movable and immovable property in the EU, because the regulation will govern the devolution of that property. Currently, each EU jurisdiction applies its own rules to govern the devolution of a person's property. It does this by applying what's known as connecting factors. And these connecting factors connect an individual to a particular system of laws. Connecting factors are, for example, nationality, which is used in jurisdictions including Spain, Portugal and Germany, centre of vital interests, which is used in Holland, and domicile for France and the UK. It's worth me mentioning, though, that the definition of domicile in the UK and the definition of domicile in France are very different. From the 17th of August 2015, participating states will all adopt a single unified connecting factor, that of habitual residence. Now that should mean that the laws of the country of your habitual residence should apply to the devolution of your EU property, but as you'll see shortly, that's not necessarily the case. Many jurisdictions also currently distinguish between the devolution of movable and immovable assets, but under the regulation, that distinction is abolished in all participating states. For Brits living in Spain, where the connecting factor is currently nationality, it'll mean that instead of their property passing under the rules of England and Wales, or Scotland or Northern Ireland, depending on where they're from, their estates will instead pass under the Spanish forced heirship rules. So what's forced heirship? Well, it's a bit like the UK intestacy rules, but it's applicable even if there's a will. And the key point is that forced heirship overrules a will. It takes precedence over it. What this means in practice is that family members will take a share of the deceased property regardless of what it says in the deceased's will, and often in preference to the deceased spouse. This can create family problems amongst Brits who are unfamiliar with the forced heirship culture. And this is particularly true where there are children from other relationships who are entitled to a forced heirship share from a deceased parent. Although I've used Spain as an example, the issue is not isolated to Spain, because almost all EU jurisdictions, and in fact most jurisdictions in the world, practice forced heirship. To further complicate matters, the regulation contains fundamental ambiguities, which mean that it's unclear exactly how it's going to be interpreted, particularly in respect of individuals who are habitually resident in the UK, who may not actually enjoy the anticipated benefit of UK succession law. The problem is that because the UK has opted out of the regulation, it's not clear whether the UK will be treated as a third state, and by that I mean a country outside the EU such as Australia or Argentina, or a member state for the purposes of the regulation. Put simply, if it's treated as a third state, then your property will devolve under the laws of the country in which it's situated. If it's treated as a member state, for the purposes of the regulation this is, it'll pass under the rules of the country of your habitual residence. I should add that just because the UK is a member state of the EU, it's not necessarily a member state for the purposes of the regulation. The point is that nobody knows for sure how the regulation will be interpreted, which means that even if you are habitually resident in England and Wales, your property could still devolve under the forced heirship rules of the country in which it's situated. I'm often asked when we'll know how the regulation will be interpreted, and the answer is not for many years. Not until the first cases are actually heard by the European Court, which could be in as much as 10 years' time. It's not all bad news though, because there is a way around this. The regulation contains a provision for individuals to make an election in their will for the country of their nationality to apply to the devolution of their estates. The good news is that an appropriate election will bypass all of the ambiguity. I should mention, though, that the use of an election has to be carefully considered, and your advisor should take into account matters such as foreign matrimonial property regimes, usufruct, taxation consequences, joint ownership structures, and other foreign proprietary rights to property. If you need help to understand your particular situation, both before or after the implementation of the new regulation, please do contact us at the Stone King International Unit, where we'd be delighted to help.